So hello friends, welcome to your channel. In this video, we are going to read chapter 11 of the book Indian Polity written by M. Lakshmikant. The chapter is Basic Structure of the Constitution. So let's start. Emergence of the basic structure. The question whether fundamental rights can be amended by the Parliament under Article 368 came for consideration of the Supreme Court within a year of the Constitution coming into force. In the Shankari Prasad case 1951, the constitutional validity of the First Amendment Act 1951, which curtailed the right to property, was challenged. The Supreme Court ruled that the power of the Parliament to amend the Constitution under Article 368 also includes the power to amend the fundamental rights. The word law in Article 13 includes only ordinary laws and not the Constitutional Amendment Act's constituent laws. Therefore, the Parliament can abridge or take away any of the fundamental rights by enacting a Constitutional Amendment Act, and such a law will not be void under Article 13. But in the Golaknath case 1967, the Supreme Court reversed its earlier stand. In that case, the constitutional validity of the 17th Amendment Act 1964, which inserted certain state acts in the 9th schedule, was challenged. The Supreme Court ruled that the fundamental rights are given a transcendental and immutable position, and hence the Parliament cannot abridge or take away any of these rights. A Constitutional Amendment Act is also a law within the meaning of Article 13 and hence would be void for violating any of the fundamental rights. The Parliament reacted to the Supreme Court's judgment in the Golaknath case 1967 by enacting the 24th Amendment Act 1971. This act amended Articles 13 and 368. It declared that the Parliament has the power to abridge or take away any of the fundamental rights under Article 368, and such an act will not be a law under the meaning of Article 13. However, in the case 1 and the Bharati case 1973, the Supreme Court overruled its judgment in the Golaknath case 1967. It upheld the validity of the 24th Amendment Act 1971 and stated that Parliament is empowered to abridge or take away any of the fundamental rights. At the same time, it laid down a new doctrine of the basic structure or basic features of the Constitution. It ruled that the constituent power of Parliament under Article 368 does not enable it to alter the basic structure of the Constitution. This means that the Parliament cannot abridge or take away a fundamental right that forms a part of the basic structure of the Constitution. The doctrine of basic structure of the Constitution was reaffirmed and applied by the Supreme Court in the Indira Nehru-Gandhi case 1975. In this case, the Supreme Court invalidated a provision of the 39th Amendment Act 1975, which kept the election disputes involving the Prime Minister and the Speaker of Lok Sabha outside the jurisdiction of all courts. The court said that this provision was beyond the amending power of Parliament as it affected the basic structure of the Constitution. Again, the Parliament reacted to this judicially innovated doctrine of basic structure by enacting the 42nd Amendment Act 1976. This act amended Article 368 and declared that there is no limitation on the constituent power of Parliament and no amendment can be questioned in any court on any ground, including that of the contravention of any of the fundamental rights. However, the Supreme Court in the Minerva Mills case 1980 invalidated this provision as it excluded judicial review, which is a basic feature of the Constitution, applying the doctrine of basic structure with respect to Article 368. The court held that since the Constitution had conferred a limited amending power on the Parliament cannot, under the exercise of that limited power, enlarge that very power into an absolute power. Indeed, a limited amending power is one of the basic features of the Constitution, and therefore the limitations on that power cannot be destroyed. In other words, Parliament cannot, under Article 368, expand its amending power so as to acquire for itself the right to repeal or abrogate the Constitution or to destroy its basic features. The donee of a limited power cannot, by the exercise of that power, convert the limited power into an unlimited one. Again, in the Vaman Rao case 1981, the Supreme Court adhered to the doctrine of the basic structure and further clarified that it would apply to the constitutional amendments enacted after April 24, 1973, that is the date of the judgment in the case 1 and the Bharati case. Now, elements of the basic structure. The present position is that the Parliament under Article 368 can amend any part of the Constitution, including the fundamental rights, but without affecting the basic structure of the Constitution. However, the Supreme Court is yet to define or clarify as to what constitutes the basic structure of the Constitution. From the various judgments, the following have emerged as basic features of the Constitution or elements of the basic structure of the Constitution. Number 1, supremacy of the Constitution. Number 2, sovereign, democratic and republican nature of the Indian polity. Number 3, secular character of the constitution. Number 4, separation of powers between the legislature, the executive, and the judiciary. Number 5, federal character of the constitution. Number 6, unity and integrity of the nation. Number 7, welfare state, socio-economic justice. Number 8, judicial review. Number 9, freedom and dignity of the individual. Number 10, parliamentary system. Number 11, rule of law. Number 12, harmony and balance between fundamental rights and directive principles. 13, principle of equality. 14, free and fair elections. 15, independence of judiciary. 16, limited power of parliament to amend the constitution. 17, effective access to justice. 18, principles or essence underlying fundamental rights. 19, powers of the Supreme Court under Articles 32, 136, 141 and 142. 20, powers of the High Courts under Articles 226 and 227. There is a table, evolution of the basic structure of the constitution. How it was evolved, you can see here. The case 1 on the Bharati case, then Indira Nehru Gandhi case, the Minerva Mills case, then Central Coalfields, then Bhim Singh Ji, SP Sampath Kumar, P. Sambamurthy, Delhi Judicial Service, Indira Sauni case, Kumar Padma Prasad, Kyoto Holhon, Raghunath Rao case, S.R. Bommai case. So many cases are there. With this, our chapter ends, and in the next video, we will cover the next chapter. So till then, subscribe to the channel, listen to the audiobooks, and study well. Thank you.